Now, we think of lawyers as never working alone. A lawyer is always working on behalf of a client. But as we discuss in this segment, professionalism involves a range of contexts. Contexts where lawyers are representing vulnerable or young clients who may not be able to form instructions of their own. Situations in class actions where lawyers may be operating with little or no client direction of any kind. And situations where clients may give direction that a lawyer simply feels uncomfortable following.
Well, it was actually my youngest client, a 10-year-old boy who came to me through his social worker from the Children's Aid Society. He and his sister had been brought to Canada for the purpose of adoption, and there were a lot of irregularities in how that took place. And he was a really troubled boy who was in a treatment center at the time that he came to us. And what he wanted more than anything was just to have some contact with his biological sister. And in the meantime, she had been adopted by the prospective adoptive mother, and he had not. Later down the road, as we won at every stage, the adoptive mother was quite angry about those proceedings, and then launched a complaint against me to the funder, and complaining about my conduct and saying that essentially this was a case where I was grandstanding. It was about me, it was about the clinic having a test case, and it really wasn't in the best interest of this little boy to be dragged through litigation. I always really felt that I had to follow the instructions of my client, so it wasn't up to me to impose my views of what best interests are, because in fact there are a lot of people out there making that decision for the child. So there's a judge that ultimately is going to be making that decision. There may be social workers, and that you have to really understand your role in that process. We would win, but then I'd have to be telling him, but they're appealing, and so this has to go on further, and it's going to take even longer. So trying to explain that to a boy who really just wants to see his sister. So we had worked in a lot of ways to keep him safe and to try and support him. But certainly there were times when he was really distraught that I was really wondering, why are we doing this? It taught me how to look after clients, I think, very much so, and I was learning as I went along about how to do that. But I don't think it made me hesitate to advocate really strongly for a client's position. I think it just made me think about how do I put those kinds of protections in place to make sure that a vulnerable client is actually being looked after. And that sometimes the lawyer isn't the best person to be doing that, so you make sure that there are other support systems in place, that the client isn't just out there on their own, if at all possible.
I was probably just past 2 years as a lawyer, and I had been working extensively with a senior partner and one of the major clients, a commercial client. And in particular, over the first year and a half or so of practice, I'd been working on a fairly extensive commercial litigation matter. And then eventually I got a call from one of the senior people at the company, and he mentioned that he had a new piece of litigation. Much smaller than the first one, but something involving product liability. And it was in relation to a company that they had had sort of a long, stormy history with, and who had been threatening litigation for quite some time. And finally they had issued a statement of claim. And I was interested, and he said not only did they want the firm to take this file, but they wanted me to be the primary lawyer dealing with it. So I received all the documents and I started looking through it, and it occurred to me from the product liability cases that I had been involved in up to that point that this was one where, just based on the documentation and some of the exchanges between our client and this other client and this other party, that there was some potential for exposure liability in this case. And depending on how you interpreted documents and exchanges, it could be significant exposure. So knowing what I knew about this company and these individuals who asked me to be involved in the case, I knew that their reaction to any kind of discussion of the weaknesses of the case or potential liability or exposure would not sit well with them. So So I was sort of faced with this dilemma of being a junior person at a law firm or becoming sort of a mid-range associate in terms of seniority with my first major case, and wanting to continue that reputation that I had developed with this client as being someone who would sort of take it right to the limit, but recognizing that, of course, I had a duty to make sure that they understood where we were at with this, what the potential outcomes could be. My initial reaction to how to deal with the fact that there was a wide range of possibilities to explain to the client, some of which they would not be happy to hear, my initial reaction was, I'm going to speak to the senior partner about how he might deal with this. But I had some level of reservation because, again, in the same way that you want to foster a reputation and a relationship with the client, you want to also maintain it with the senior people in the firm. And I didn't want to give the impression that somehow this was becoming over my head or something that was getting unwieldy for me. After some thinking about how to best approach it, I decided that I would prepare what was probably far too long of a legal memorandum so that I would at least have just almost like speaking notes and give it to them so that they could sort of follow along with the law. And I made sort of a flow chart that involved the various possible outcomes of the litigation. They listened intently, and they sort of smiled after I was finished sort of presenting the information to them, and they thanked me for the work, but they did say, you know us, and we're ready to take this all the way. So I said, all right, then let's do this.